alive, and he's able to share these perspectives some 40 years later.
And he's real.
And he's real. I'd be interested that the high school students had access to him to bring before the group that stated that their request for participation in the competition wasn't validated. Well, Wallace said that the perspectives weren't particularly encouraging, and that suggests, since I got a chance to speak last night, not to bring the good news. It's interesting that if this is the good news perspective, I can imagine how you will assess the comments which preceded within those contexts. And we asked the question, and I've been asked to, and I'll come to Helen, what additional perspectives might be brought with respect to Gault that has not already been addressed in the previous presentations. And in our reflections, I wondered if there was substantive information available that would allow us to have a conversation on the impact of the Gault decision with respect to minority youth who are involved in the system. And like each of the previous presenters, it's important to explore the literature to see what kinds of comments have been made, either with respect to the litigation which has taken place thus far, the law review articles, or comments which may have been addressed with respect to disproportionality, and the extent to which legal representation for ethnic minority youth is also a concern. And though there aren't any practitioners who would dispute the need for addressing the needs of children, not just of ethnic minority status, but probably in a much larger sense, children whose families are economically challenged, the degree and quality of services they receive. However, those have not yet been documented in such a way from a purely legal context that we can bring to you and share either what the cases have said or what discourse has shared by way of law review articles. So we'll take a slightly different perspective. One is that in addition to Gault being 40 years old, we had a comparable federal statute. The Office of Juvenile Justice and Delinquency Prevention was created by the Juvenile Justice and Delinquency Prevention Act of 1974. And that act has been amended four substantive times since then. In 1988, the Juvenile Justice and Delinquency Prevention Act was amended, requiring all states that receive federal funds to assess the extent to which disparate treatment or disproportionality existed within their states. And because each state now receives those federal funds, we have the body of data which shares with us the extent to which ethnic minority youth are represented in correctional facilities in numbers disproportionate to their representation in general population. And what that means in substantive terms, in many communities across the U.S., you'll find that a specific demographic of ethnic youth, African American youth, Hispanic youth, Asian youth, Native American youth will comprise maybe 20–25% of a given community. And if you look at the correctional facilities, detention centers, training schools, secure facilities, those numbers exceed 50, 70, 80, sometimes 90%. Thus, the question of disproportionality has been defined as the extent to which youth who are involved in correctional facilities exceeds their representation in the general population. And those numbers are not in dispute at any point. If you were to look at the data, you would find that those are indeed the case. And if we were to ask the question regarding how Roper, and I sort of want to fast forward and use this part of my discussion, the continuum between Gault and Roper, if we'd ask the question, how did Gault impact the issue of youth of color who are involved in systems, and then use Roper as sort of where we are by our most recent standard. It's interesting that Gault has set a standard that Roper has provided for us a bar for which science is not ready to meet. And Professor Rosenberg, I think, asked a question, maybe we could have this conversation about this issue around adolescent brain development. Case precedent in stare decisis has clearly been the maxims associated with how the law moves forward. And in very, very, very rare circumstances will you find a court take a leap of faith and say, on this day, we decided the cows come home. That this is really at the point when we take a turn with them and go on. And Roper, and Wally, you raised the question on, I'm not so sure that Roper is doing the kinds of things that we want for children, because it may be, again, questioning whether children have the ability to make these decisions with respect to rights. For all of the benefits that we have associated with Roper, now have this concern about whether it questions the ability of children to participate within the legal process in ways in which Gault encouraged. But equally challenging is the science is not ready to meet the standards of rule. We have now, by way of a Supreme Court ruling, that children are different, at least in a legal sense, from adults. However, the science that proves that children are different from adults is soft science. We just know that the brain develops somewhat differently and children have somewhat different capacities from adults. But if you ask a physiologist to share with us the exact parts of the brain that make this difference, or to give us concrete examples of ways in which these cortical developments are specifically different, you find that what we can do is look at regions of the brain where activity occurs, but not have specialized localization of the functions which are associated with those differences. Now, what this might mean in sort of terms that wouldn't have a jury sort of glazed eyes over with that kind of discussion is, if a person is learning to ride a bicycle, then the ability to ride with 2 wheels versus training wheels may come at a fairly early stage in the developmental stage of competence to ride a bicycle. But by age 16, 17, 20, certainly about 30, there are a degree of competence associated with riding a bicycle, which is pretty much assumed. And what we suggest in this area of differences in brain development of children versus adults, there is a confusion with the ability to verbalize what a child understands, and competence is associated with the exercise of those facilities. Similarly, if a person were learning to play piano, there may be the ability to read a sheet of music and to play the sheet of music correctly, but at some point there's a degree of competence which allows the sheet of music to be put aside and the person to be creative with the playing of that piece of music. And that's sort of what happens with the brain. If you ask a child, do you understand from an attorney's perspective, do you understand what I'm sharing with you? The child says yes. And you ask the child, what are your preferences with respect to the options which exist? I'll share with you the options and I'll make my very best case to help you achieve those options. What would you like to take place? So will the child's retort to the attorney that they understand what's taking place, and the child also exploring the options for which they would like to see achieved with respect to the issues which are before them, I think in many instances mislead the participants at the adult level into concluding that the child has a degree of competence associated with the conversation. Because to see an individual ride a bicycle at age 8 doesn't prove more than the ability to keep it upright. It doesn't describe the degree of competence that Lance Armstrong had. To find a person being able to play a sheet of music doesn't indicate that a person could be creative and write music as well. And I think we're giving the children the ability to write music when what they're basically able to do is understand the language. And understanding the language and being able to engage in a conversation has been extraordinarily misleading in our conversations with the degree to which children can participate in adjudicative and decisional competence. I think somewhat equally challenging in this regard is the concern and perspectives associated with cultural differences between the representative for the child and the child, him or herself. And the challenge, I think, both representatives in courtroom environments have, and also child advocates experience with this degree of culture, is fully understanding whether one's own culture is sufficient for understanding what the child would choose if they had confidence in the person they had as legal representative. One way of thinking about this might be being able to sit around a family dinner table in the evening